Now, Julia.
Thank you, Susan. Thank you, Natalie, for organizing this. And thank you all for joining us today. It's an honor to be here. I always enjoy the opportunity for me to meet with folks who are doing this work every day, work related to reducing harm, increasing safety, providing protection and access to justice for folks in California. I am coming to you today from Connecticut, actually, where there is a symposium happening at Wesleyan on the intersection of guns, domestic violence, and federal law primarily. So it's exciting for me to be with colleagues here, having those discussions in light of the Fifth Circuit opinion, Rahimi, which I'll also be talking about today. My plan is to get through the material because, as Suzanne and Natalie have mentioned, this is set up as a webinar. My understanding is you'll be able to put questions in the Q&A or chat and so forth, and we will get to them, I'm imagining, after about an hour or so of material. But there's always plenty to think about and discuss. So we'll see how it goes, and I'm going to cover a few different areas that I hope will be of use to you in your work. So I want to start with some good news. This is a heavy topic, obviously, with a lot that we're all concerned about. And in California, I feel like we're very lucky because we have a lot of tools available to us. And one of them is SB 320. SB 320, which I'm going to go into more detail on soon, addresses firearms relinquishment in the domestic violence context. And one of the things I'm sharing here at this symposium where I am right now is about SB 320 as a model for the rest of the country. And it's a model for several different reasons, including that it requires that people who become prohibited get information about how they can comply. That sounds pretty straightforward. Often we focus on what are we going to do when they don't tell us about the firearms, when they keep the firearms in violation of a prohibition. And of course, that's a concern. But we also know that when we have processes in place that ensure relinquishment, when we invest, as we have in California, $40 million in one-time state funding to support implementation, we know from national research that when we have those kinds of procedures in place, we see a 16% reduction in homicides related to domestic violence and firearms. This is huge. Obviously, the goal here is to save lives, to reduce injury, to increase safety. So in my view, we know a lot about what we need to do, and much of what we need to do, given the prevalence of firearm ownership in this country, there are more firearms that are privately owned in the United States than there are people. Given that, we have to take a harm reduction approach. We know other things are dangerous in our country, and what we've done is not necessarily assume that we can just get rid of them, or even that we should. There are many responsible gun owners in our communities. We have supported firearm ownership and use in the context, obviously, of the law enforcement folks and others in our communities. But we have to approach this, again, with an emphasis on reducing harm and increasing safety. And when we do, when we have the kinds of policies I'll be talking about today in place, when we actually implement them, we can save lives. And why does this matter so much? When I do this work, I think not only about everyone who's joined this call and the various experiences that you likely have had with firearm violence and domestic violence personally, and of course in your professional work. I also think about the victims that I either work with or know about through media reports. This is a group of siblings who, some of whom were killed, some of whom were injured by a boyfriend of their sibling, their teenage sibling, who was experiencing domestic violence by her boyfriend, who was still, I would consider a teenager, but over 18. He had an outstanding bench warrant for maintaining firearms in violation of a prohibition. This is in Prince George's County earlier this year in January, and had been abusive, continued to be abusive, and committed an act of mass shooting in their home. I think about Callie Trout, formerly Callie Garay, who was murdered by her husband after she sought and was successful at obtaining a firearm prohibiting domestic violence civil protective order in California. The judge granted her request. In the 12 pages that she submitted to the court as part of her request, she discussed how often he had threatened her with a firearm, that he had threatened to kill her. She sought protection for herself and for her children. On the record, the judge said, "I'm granting this order. I see no evidence that there's any concern about firearms here. You are prohibited," he said to the restrained party, to her husband. But by saying that, he failed to emphasize that, in fact, he needed to relinquish his firearms and that he was concerned, or should have been concerned, about the access that he had to firearms. And soon after she obtained that restraining order, he tragically shot and killed her in front of her children. I also think about the mass shooting victims in Sutherland Springs, Texas, for example. These are folks who were just some of the people who were killed in that tragedy, that enormous tragedy. The perpetrator in that case had been prohibited, similar to Mr. Garay in Callie's situation, had become prohibited as a result of a domestic violence restraining order in Texas. Unfortunately, the military failed to enter that prohibiting order into the database, into what we would think of as CLETS. This is critical. It's important in California. We have a case right now going on where the Department of Justice is being asked to turn over information in a case involving Wyland Gomes, who was a little boy who was shot and killed by his father. The firearm he used, he obtained while he was prohibited as a result of a restraining order. It appears as though that restraining order was not immediately entered into CLETS. In fact, it wasn't entered into CLETS until it was about 2 weeks away from expiring. And that meant that when Mr. Garay in that case and the perpetrator in the Sutherland Springs case went in to purchase a firearm, there wouldn't have been any prohibition. In the Sutherland Springs case, he was able to purchase a firearm legally through a licensed firearms dealer. So we have to look at how we are entering these orders. We have the majority of mass shootings involve some connection to domestic violence, the vast majority of mass shootings. So this impacts not only the immediate victims who may be experiencing domestic violence, but our communities more broadly. And so this is a very heavy topic, a very painful topic. Dr. Garen Wintemut's research in California tells us that the majority of Californians have had some exposure, some experience in EV to gun violence, whether it's walking past a memorial regularly, knowing someone who has lost their lives to gun violence, their life to gun violence, or reading about it so routinely, listening to bullets fly in their neighborhood, all different ways that we are struggling with the trauma and stress, and then the direct loss and grief associated with firearms violence. In the domestic violence context, we have both criminal and civil approaches. And one of the things I want to do to help place the Fifth Circuit decision that I'll go into in a moment, the Fifth Circuit being Texas, Louisiana, and Mississippi. That's the federal district court that covers those states, or the circuit court that covers the federal courts in Texas, Louisiana, and Mississippi. They recently issued an opinion called the Rahimi case, R-A-H-I-M-I, that I'll talk about more, that found unconstitutional the federal prohibition on having firearms in the context of civil restraining or protective orders. Doesn't directly impact California at this point. There's a request for the Supreme Court to hear that case. But it raised a lot of questions about sort of what is the significance of civil restraining orders in the domestic violence context. if this is so dangerous, why isn't it all being handled in the criminal context? One of the things I like to point out, as someone who's very interested in history, and in the situation in which the Supreme Court's test now emphasizes what is the history and tradition of regulating this area with respect to firearms in particular. I like to point out that protective orders, civil responses to domestic violence are not new. You can see this description here involving a situation in which a woman was married. She was trying to earn a living. Her husband had been in and out of jail as a result of domestic violence. He had nearly killed their child. He kept coming back and being even more violent. She went ahead and applied for, as the report provides, for a protection order. I would imagine if we were in a smaller group and had an opportunity, I would ask you to guess when you think this happened. I don't know, Suzanne, if you're listening or if you have a guess on this, but since I can see you and I think you can chime in, if you can imagine around what time this case might be happening.
You mean what time, as in like this
Yeah,
year?
what year? Yeah, what year?
I'm thinking this year.
Yeah, it could easily be this year. I think that's what's interesting about it. This is a case that was from 1868, around that time. Frances Power Cobb, who was the first person to advocate for a civil protection order approach in domestic violence cases. She was in the UK. She was an Irish activist, a suffragette, who wrote about abuse of animals as well as child welfare and domestic violence. Was the influence behind the initial protection order approach, which said we need to comprehensively provide remedies for women in these situations who are experiencing what was then referred to as wife beating, that can include financial support, that can include protection of children. The wife in that case was unable to get a protective order because he had not deserted her and she wasn't getting divorced. Historically, you could only get that kind of financial protection and custody of the children in the context of separation or divorce. But that's the earliest. So we're talking about the late 1800s for a civil approach. And it is often thought that somehow we weren't regulating domestic violence criminally. We can go back to the Plymouth colony here in the United States in the 1600s through the 1700s, and we know we have laws that said it is not okay to beat your wife under these circumstances. Yes, we had coverture, which meant that legally the woman had no rights when she married, and the man did have a right to use a certain amount of physical force to correct her misdeeds. And at the same time, there was regulation of domestic violence. So we have been regulating domestic violence, maybe not consistently, not fully implementing the laws. That's also not new, for a long, long time. Lucy Stone followed up on this. Lucy Stone, who was an activist, suffragist here in the United States, followed up on Frances Cobb's work in the United States, also in the late 1870s, tried 3 times to have a similar kind of law passed in Massachusetts, wasn't initially successful. Eventually, there was some
Julia, is it my internet or your
put in
internet?
place. One of the concerns that it was too easy and to end their marriage. So, Suzanne, you can go back on mute if you'd like. We had various efforts over the years. Again, I'm just adding a bit of history here because there is a sense that this is all brand new, that we haven't been regulating domestic violence for a long time, that we haven't acknowledged the dangerousness. My argument is that we have inconsistently recognized the dangerousness. This is an article from the Lassen County Times from 1989, or 88, I should say, from January of 88, where a new law had just gone into effect in California. Several new laws had, Again, in support of recognizing the dangerousness around domestic violence. One of the new laws was that law enforcement could remove firearms at the scene of a domestic violence situation. Again, this is from the 80s, long before the federal law in question in Rahimi was put in place, and long before SB 320. So we have had various legislative efforts to recognize the seriousness of domestic violence and to try to do something about how firearms intersect with domestic violence and cause harm in our state. Why criminal? Why civil? What are the differences? Again, since we have a diverse set of professions here on the call, I just want to highlight some key differences because I get this question a lot. In criminal matters, the criminal case is led by the state. That is, only law enforcement and prosecutors can move forward with criminal matters. Sometimes you'll hear, well, is she going to press charges, or are they going to press charges? While it matters whether a victim, survivor, or somebody harmed by somebody else is willing to participate in the process and provide relevant evidence, they are not the people who get to decide if a case moves forward. Criminal matters are initiated procedurally by prosecutors filing an indictment. They may go to a grand jury and get members of the public to join in and decide as to whether or not an indictment, an accusation will be filed. But again, the state ultimately makes the decision. In the civil context, a private party is initiating the case against another party. Under criminal sanctions, there are felonies, there are misdemeanors. That has a lot to do with the level of harm that's being charged and the resulting loss of liberty, jail time or prison time. Both of these are firearm prohibiting convictions under both state and federal law. In the civil restraining order context in California, firearm prohibitions are put in place at the emergency or EPO stage, at the ex parte stage, and at the order after hearing stage. They are only in place in the civil context while that civil order is in place. In the criminal context, they are either lifetime prohibitions or under California law, they may be limited in time to 10 years, for example, misdemeanors. But under federal law, we're looking at a lifetime prohibition once a conviction is in place. You can also order criminal protective orders, CPOs, in the criminal context before somebody is convicted. Those are firearm prohibiting. And we have two different versions of those. We have one that is domestic violence specific and one that is designed to protect witnesses generally in cases. And the idea is to provide certain aspects of protection similar to civil orders, not as comprehensive, but they can address child custody matters. They restrict someone's ability to contact the protected party. And again, the idea is to make it more likely that someone who has experienced harm can participate fully in that criminal case by being protected from somebody who may or may not be limited in their freedom because they may be out of jail, out of custody, and could harass or harm the protected party if that order wasn't in place. In the criminal context, we have relinquishment procedures, largely under Prop 63. So the people of California weighed in on this, the Comprehensive Crime Prevention Bill or proposition, I should say. Under Prop 63, that's covered now in the Penal Code in the 2900 sections, we have various obligations for probation officers to ensure as part of the reports that they issue that somebody who is on probation has relinquished any firearms that they currently own. That needs to be reported to the judge. If there's a violation, that information goes to the prosecuting attorney. We have similar procedures I'll talk about in SB 320. One of our goals here in the policymaking area in California is to have a more consistent approach to firearm prohibitions and relinquishment, so that no matter how someone becomes prohibited, we treat them similarly in terms of ensuring any currently owned firearms are turned in, stored, transferred, or sold, depending on what makes the most sense for that firearm owning individual. In the criminal context, search warrants are available. They're also available in the civil context. Penal Code Section 1524 provides the basis for requests for search warrants. That's the law under which a law enforcement officer or a prosecuting attorney can contact a judge and say, Your Honor, here's the reason why a search warrant should be issued. So a violation of a civil restraining order or refusal to turn in firearms when you have become prohibited in the domestic violence context or in a gun violence restraining order context, both of those serve as a basis for a request for a search warrant. And again, you can do that in the criminal context under a variety of other provisions as well. In both contexts, because someone has been harmed, it's possible that they will have access to victim services, depending on what the DA victim services might provide. In some counties, the district attorney victim services works with people regardless of whether or not they have a criminal case. In others, they're limited to situations in which there's a criminal case. And there may be witness compensation as a result of the harm they've experienced. So you may have those procedures in place, but if not, that's something to be thinking about. A few other aspects of civil that I want to touch on is that one of the reasons the civil concept came to be is that there were real concerns with relying on law enforcement, either law enforcement officers or prosecutors, to determine whether or not somebody would get protection. Because that means another person would have to decide what was at stake and what kind of protection made the most sense. Civil orders, like Francis Cobb worked on in the 1800s, were designed to take a much more comprehensive approach, to look and say, this person may be unsafe because they don't have enough safe housing and access to resources. There's a difference between what men could earn in the workforce and what women could earn. There may be a need to transfer some resources to mom and the kids in order to increase their ability to keep themselves safe. There was concern about the children being at risk and who is a more protective parent. So those are not areas that the criminal system adjudicates. The criminal system addresses whether or not somebody should be removed from society. And maybe there's some services associated with rehabilitation, but the primary focus is whether or not we're looking at restricting someone's freedom in the criminal context. And civil has much more injunctive, broader relief available. One difference that's significant is you're not entitled to government-funded representation in the civil context. In the criminal context, you have a right to counsel and a right to government-funded counsel if you can't afford an attorney. You have a right to counsel in the civil cases. You can bring an attorney, but you have to be able to afford that attorney or otherwise avail yourself of free or lower cost legal services. But one of the things that sometimes gets mixed up for those who may be concerned about domestic violence and firearm prohibitions in the civil context is somehow there is a due process in the civil context, which is simply untrue. Due process requires two things: notice and an opportunity to be heard. Notice, you can't be hauled into court if you don't know you're supposed to be in court, and having your freedom or your rights or your money being allocated in ways that you didn't know about. So you're entitled in the United States to notice, and you're entitled to the right to present evidence. And that's true both in the criminal and civil context. Similarly, you're always entitled to have an attorney. But again, the difference is neither party is necessarily entitled to an attorney in the civil context. So that's one reason we see a significant number of self-represented litigants in the civil context. I think that's what I want to touch on there so you have an understanding of it. Now, we have an excellent report that the ACLU did in 2015 that talked about why it was that victims, survivors of sexual assault and domestic violence would not necessarily, generally, rely on the police or the criminal courts. Again, this dates back to at least the 1800s. A lot of similar responses. It's interesting. There's some things that are quite modern in terms of concerns, but the underlying basis for the concerns is somewhat similar insofar as law enforcement officers not taking the violence seriously, seeing it as a private matter, not wanting to intervene as a state officer in a situation that they saw as intimate and private. And we also heard from survivors through that survey that they were looking for options that were broader, options that didn't just focus on punishment, which is what the criminal system is often focused on, punishment and, again, removal from the community. They didn't necessarily always want to separate from the abuser. They might, as they reported in the survey, and we know from our work, recognize that it would be impossible to separate because they will always share custody of the children. And they're going to be in touch whether or not there's violence, but they want the violence to stop. And they want that to happen in a way that doesn't prevent them from having access to housing, to health insurance. There are also concerns when I referenced contemporary concerns, concerns about immigration status, concerns about bias that's centered on gender and race. Folks from the LGBTQ plus community have raised concerns about interactions with police. And survivors reported all of these themes back in 2015 that are, of course, are still relevant this, a few years later. This one about losing control of the process, again, very similar to some of the concerns that we saw if you look at the historical documents in the 1800s about wanting to have some more control over where the case goes and not just rely on the state to determine what's said and what happens next. And the bottom line is that if you have more control over the process, you may feel as though you can lessen the concern about the level of trauma. Doesn't mean you eliminate it entirely, but the complexity, the length of time, how long it will actually take to get some kind of resolution, you have much more control over that in the civil context. So that isn't new. In California, again, I say we're lucky that we do our work in California in a context where we have recognized the value of civil approaches. You have a set of handouts. I don't know if they've been given out yet, but they are part of today's webinar. So if you don't have them yet, you will have them soon. It includes this chart, this civil restraining order chart that I created that is based on charts that others have created. I think about it sort of like folk music. It's, we enjoyed some music here at the top of the hour. In folk music, those of us who are big folk music fans know that sometimes it's hard to figure out if Bob Dylan wrote it or the Byrds wrote it or somebody else wrote the song. Joan Baez, lots of other players took various aspects of songs, Pete Seeger and so forth, and turned them into their own songs with homage to others who came before them. So this chart is sort of like the folk music approach to trying to get good information out to the state about the various civil orders of protection or restraining orders that we have in California that are firearm prohibiting. So many states only have aspect to one or two firearm prohibiting remedies. Some have none. and have to really rely on the federal law when they're trying to protect folks in certain situations. Here we have not only domestic violence restraining orders, but we also have elder abuse orders, civil harassment orders, workplace violence prevention, school violence prevention orders, and gun violence restraining orders, among others. So all of these are firearm prohibiting. They all have their various requirements. All of them name both a petitioner, the person who asked for the order, and a respondent or restrained party, except the gun violence restraining order. The gun violence restraining order is the only order that does not include a named protected party. You have a petitioner and you have a respondent. The petitioner is asking the respondent to be prevented from having access to firearms and ammunition because that person may be a harm to themselves or to others generally, but not to a particular person that they might be abusing or harassing. So if there's abuse or harassment around a workplace, a school, an individual that they're related to, or even a neighbor or someone that they have been stalking, or someone who might be somewhat of a stranger, then you're looking at DV, civil harassment, elder abuse, workplace, or school violence prevention orders as being more responsive than the GVRO. Other states don't have all of these options. So this is an important chart, I think, in terms of giving you some specifics. Again, I can't emphasize this enough. Domestic violence is perpetrated in such diverse ways, and in order to reduce the risk of lethal outcomes or injury to the adult or other household members, or even to the broader community, we have to find ways to have the state intervene to provide protection and control over the person who's perpetrated that violence. And when I talk about, those of you who work in the courts or who are very familiar with civil restraining orders know this already, but I'd like to really emphasize and highlight the various remedies that we have in California. It's a civil court order in a Domestic Violence Prevention Act case that can help protect a family, an individual. It can prevent access to certain locations, work, and other places. It can restrict any use of physical force, no contact. It can say you can't contact the person by phone. It can require that they move out of a location, even if they own the location or co-own the location. It can send them to services to try and prevent future harm, which is often, as noted earlier, very important to victim survivors. It can help reduce danger to pets or support a survivor who's concerned about harm that might be done to a pet. It can support them in being able to make that decision to separate and protect the animal. It can allow otherwise illegal recordings to happen. Can include child custody orders. It can include financial remuneration and order that bills be paid, including transferring cell phones. It can include attorney's fees, and all of these orders are firearm and ammunition prohibited. So this is a very comprehensive remedy. Not all of these remedies are at all available in the criminal context. And these are all designed to reduce risk. So to go back to the Rahimi case, since that's on a lot of folks' mind, even if it doesn't directly impact California, one of the themes that we've seen, and it's gotten a lot of national media attention, and the Supreme Court, we believe, is likely to hear the case because there's a lot of back and forth in the federal courts right now about the Supreme Court decision that was made last year in a case called Bruin. That was a case involving a New York state law that restricted a person's ability to move their firearms from one place to another. And the Supreme Court, in an opinion written by Justice Thomas, said that it was in order to determine whether a prohibition that either Congress or state legislatures make on someone's access to firearms, in order for that to be constitutional, there's a two-step analysis. The first step is to determine if the regulation that the legislature has issued burdens someone's Second Amendment rights. And if the court finds that, yes, in fact, this burdens their Second Amendment right, then it's only going to be justified if they can find a historic analog, if there's an analogy to that prohibition. Now, Thomas, in his opinion, said there's some question about what's analogous, because we can look at, and he used this example, you have a green truck and a green hat. Are they the same because they're both green? Or are they different because one's a hat and one's a truck? So depending on what level of analysis you use, you're going to have different opinions about that. And it's for the courts to, over time, develop an understanding of whether or not something is the same or different. And that's exactly what has happened. We now have disagreements all over the country from federal courts about whether certain firearm regulations are in fact analogous to the ways we have regulated dangerous people or dangerous weapons since the beginning of our country. And with respect, especially to the domestic violence prohibition under federal law, and there's two of them that are relevant here. 18 USC 922 G8. I'll say that again in case you're taking notes. 18 USC 922 G8 says that you can't have a firearm under federal law if you are subject to certain qualifying civil restraining orders. And there's a variety of things that have to be in the civil restraining order, and it's limited to people who have been married, have a child in common, or are otherwise fit the definition of the kind of violence and relationship. So that's where we get into the dating loophole. In California, we've closed that dating loophole so that if you have a civil restraining order, you are firearm prohibiting. But under federal law, in states that don't have state law in place, they're subject to only that federal law. There's also 18 USC 922 G9, and that addresses the misdemeanor crime of domestic violence, which also makes you firearm prohibiting for the rest of your life if you meet the definition of a conviction under that domestic violence misdemeanor provision. Why is it limited to misdemeanors? Because already under another section of 922G, felonies are felonies regardless of whether domestic violence or not, make you firearm prohibiting. So one could argue there are three ways you get prohibited in a DV situation, but the felony prohibition is not specific. You can also become specific to DV. You can also become prohibited for lots of other reasons, including certain kind of felony indictments as a result of being someone who's abused narcotics, mental health admission and evaluation. But just to focus on the DV piece here, in the Rahimi case, where Mr. Rahimi had agreed to a civil restraining order with his former female partner with whom he had a child in common in Texas, he stipulated to a civil restraining order. And under both Texas state law and under the federal law, the order qualified and made him firearm prohibiting. I want to point out that there was no effort as far as we know, at any point to ensure that he was separated from any currently owned firearms at the time the prohibition went into place. He subsequently ran around Arlington, Texas, shooting up the community in various ways. He got angry at a Whataburger restaurant and shot into the air when a credit card didn't go through. He got angry at the scene of a car accident and shot into the scene of the car accident, drove away, came back, shot it up again. He shot at a constable, at a government official, and was eventually arrested for these various violent activities and was charged with violating 18 USC 922 G8, the prohibition on having a firearm when you have a restraining order in place. So he was never prosecuted for domestic violence, which is really important. The only way that the federal law is generally used in some jurisdictions is as a prosecutorial tool after the fact, which is different than what we are trying to do in California and that many other local jurisdictions are trying to do. And so when he appealed his conviction after that Bruin decision was made, and he said, wait a minute, this burdens my Second Amendment rights, and there's no historical analogy here. And initially, before Bruin, the federal court said, nope, this passes the test, the conviction stands. After Bruin, when he appealed again, they heard the case. And in February, a 3-judge panel in Texas, federal panel in the Fifth Circuit, ruled that this provision 922 G8 was unconstitutional because there was no historical analogy. In the opinion, they go into a lot of detail about what's wrong with civil approaches to domestic violence. And they heavily emphasize that if, in fact, the intersection of domestic violence and firearms is so dangerous, then those individuals should be handled by law enforcement, prosecution, and incarceration. And that's where the firearm prohibition should be focused. And that, in fact, these civil approaches are not necessary or appropriate in these cases. There's a lot of very harsh language that suggests that somehow civil judges aren't capable of making decisions about whether or not to issue civil orders. An extremely controversial decision, and there's a number of us who are working around the country on amicus briefs to the Supreme Court, and there will be more revealed on that, but happy to answer some questions. Now, one of the areas where this questions come up about Rahimi and other issues related to civil orders is, wait a minute, what about ERPOs, extreme risk protection orders? In California, we call them gun violence restraining orders. As I've already mentioned, these are very different because they don't name a protected party, and for that reason, do not provide the level of protection that DVROs provide. There's no foundation for Family Code Section 3044 or Family Code Section 3011 or any of the best interest concerns. In fact, if a judge sees someone has a GVRO instead of a DVRO, it would be an indication that there wasn't domestic violence. There was only concern about firearms and ammunition. We know that when survivors, when victims of domestic violence go to court, speak out, say, I need help, tell the truth about what's happening in their relationship, risk increases. It's a very, very dangerous time. It takes a lot of courage and a lot of safety planning. And so we want the best, most protective legal approach, if that's going to be what folks rely on, possible. And GVROs simply can't provide that in cases where domestic violence is an issue. The orders, again, generally will include the same firearm prohibiting remedies, no matter if it's a GVRO or a DVRO. GVROs were really designed as a suicide prevention tool to protect a loved one. That's why family members who often have good information about their loved ones being at risk can pursue them. And law enforcement, when concerned about generalized mass shooting threats, are also in a position to pursue gun violence restraining orders. 96% of GVROs in California have been sought and obtained by law enforcement. Those federal laws that I've talked about, they don't apply in gun violence restraining order cases. They have no applicability. They only apply in domestic violence cases, which is significant for full faith and credit across state lines and involvement of federal authorities. Some people say, well, why don't they get both a GVRO and a DVRO? Again, totally unnecessary, same prohibitions, and appearing multiple times in court is another way to increase risk. If that's necessary in certain instances to get perhaps a civil harassment order and maybe a DV order or an elder abuse, maybe. But one of the things we've done in California is make that unnecessary in almost all instances because of the comprehensive approach. When we fail to do what we know needs to be done, which is to obtain the firearms as close to the time of prohibition as possible, when folks who own firearms and ammunition become prohibited, we end up with those folks in the Armed Prohibited Person System, or APS, in California. We're the only state that has APS, the only state that can count the number of people who are known to the state of California for owning firearms and who are also known to the state of California as being prohibited. And in California, we've had historically well over 24,000 people who are known to be armed and prohibited. This year, for the first time, or I should say last year in 2022, it's the first time we've seen a decrease in that number. So it's a couple thousand less than what we have seen in the past, which is significant. And the Department of Justice in California attributes that to that initial description I provided at the beginning, a greater investment in policies like SB 320. This is a picture here of a situation where we had an individual who was employed by the Federal Bureau of Prisons, lived in San Diego. He became prohibited as a result of a domestic violence civil restraining order. He failed to comply with turning in the firearms, and a significant time later, the Armed Prohibited Person System, the APS team, did what we talk about as a knock and talk, which they can handle about 2 or 3 of those cases a day, where they look up somebody's address, phone number, they make contact with the person. In this case, he claimed that he had turned over all his currently owned firearms to his employer. They contacted his employer, the Federal Bureau of Prisons, and they said, no, we've never gotten any weapons from him. They got a search warrant and they went in and they found over 3,500 rounds of ammunition, multiple long guns, multiple handguns, most of which were not registered. Some of them were registered, some of them were not. This is a picture of what they obtained from this person, again, who had committed acts of domestic violence, had been restrained for a long time as a result of that restraining order, and was still able to maintain possession of these weapons. We need to do a better job. We also need to do a better job looking at how we handle child custody stipulations in these matters. We have some legislation that's being proposed on this. This is a picture of the restraining order in a case in Sacramento, where parties went in, mom and the girls were living in a confidential location. The court ordered, according to their stipulation and requests, ordered the restraining order be put in place. And you can see it included the personal conduct orders, the stay away order. It included some of the other provisions. You could record unlawful communications. It ordered them to schedule a mediation with family court services. And you can see number 9 there, which isn't a checkbox, which was a decision we made at the Judicial Council years ago to eliminate the checkbox because it is standard, not optional, not up to judicial discretion, that firearms be turned in within 24 hours of being served with the order and within 48 hours, there should be a receipt in the file indicating that. So dad in this case was a prohibited party. They ordered supervised visitation between dad and the children at what I would consider an unsecured location, church, with a church member. Ordered him into anger management. Again, this was ordered through a stipulation. And I'm emphasizing that because a stipulation in a case involving power and control warrants significant review by the judicial officer to determine if this order is still in fact, even if they've agreed to it, is still in fact in the best interests of the children. Tragically, it was not. Father obtained a firearm on the way or sometime between this order being issued and the visit, an unserialized so-called ghost gun, and brought it to the visit and killed the children. And the supervised visitation monitor, an untrained, non-professional who had volunteered to assist the family as a member of their community. Again, we can do better and we have to do better. So SB 320, in the next few minutes, I'm going to wrap up here with this. SB 320 is designed to address a lot of these issues. We've had a lot of these policies in place before, way back in 2014, as a matter of fact. I was part of a team that developed the initial rule of court in this area. And we decided, we being Giffords, where I was the implementation director back in 2021, to pursue turning this into a statute to draw more attention to it. And also to seek that additional funding for implementation. So the law changed some aspects, and it highlighted long-standing aspects of this approach. The requirement is that courts run what's called a 6306 check, so they can get good information from CLETs about someone who might currently own firearms, might have an outstanding bench warrant, so that they can make the right kind of order in a domestic violence civil restraining order matter. The court must consider whether there's been any kind of violation of the prohibition in handling this case. They have to make a written determination of it, and they have to provide it to the parties. Courts can consider whether there's been a violation by opening the file and seeing if there is that form that's required to be submitted, that I'll highlight in a moment. Or they can hold review hearings, but courts are required to take a look once they've determined that firearms are an issue in the case. They're required to review the court file to determine if that's happened. It's automatic, like I said. Number 9 is on the civil restraining order form. The court shall, the court must, the court will automatically prohibit access to firearms and ammunition. There's a limited exception that the court can make if the person is a peace officer or a law enforcement officer. And there's a process under Family Code Section 6389 for them to determine if someone can maintain a firearm despite the prohibition. And that has to be applied carefully through a very specific process. When law enforcement shows up at the scene, they have to remove any firearms in plain sight or that are found through a consensual search. And anyone who is told you have to turn over your firearms must turn them over upon request by a law enforcement officer. DV-800 has been in place for some time, DV-800 info, I should say, that provides information in all of those civil restraining order contexts. There's a GV-800 info and one for civil harassment and for all the other items on my chart. But that isn't adequate. Under SB 320, you have to provide information locally about how to comply. So those are generic, sort of, this is what the state law says. But Every jurisdiction for a long time now is required to have written protocols from law enforcement in place about how to obtain these firearms. And now the court must provide specific information about how to comply. So I know we have people from different courts on this call. I just sharing here one example from Santa Clara. We may have people from Solano, Contra Costa, other Bay Area counties, or even outside the Bay Area. Hopefully, again, this law went into effect January 1st, 2022. We should have 58 examples of this kind of local information sheet. If you don't have that and you need some support around that, let me know, talk with your court. If you're in the court, again, reach out. We can provide more examples, but this requires some effort to make sure people get concrete information about how to comply. And then really moving towards me wrapping up here so we can have some time for questions, addressing violations. When there has been a violation, courts are now required, that's the family court or the juvenile court, the court issuing the domestic violence restraining order. Courts are required to let the prosecutor and law enforcement know when there's been a violation. They have to notify law enforcement immediately, and they have to notify the prosecutor within a couple of days. And that's so that the right entities can take action. These are criminal violations once there's been this kind of violation. We like to lower the incidence of those violations. And anecdotally, I can tell you, courts are reporting to me that since they've been providing information about how people can comply, they've seen an uptick in compliance. So we are seeking to avoid unnecessary exposure to the criminal legal system while we're also hoping to reduce risk and increase safety. We're not going to capture everybody, but we are capturing some of those firearms and lowering that risk for families by taking that kind of action. There are also consequences for child custody if you don't comply. The court must consider that as a factor in looking at Family Code Section 3044, the rebuttable presumption against joint or sole legal or physical custody when there's been a history of domestic violence in the last 5 years. A violation of the firearm prohibition, firearm and ammunition prohibition is one of those factors. So it makes it less likely that someone can get joint or sole physical or legal custody if they don't comply. And there are civil and monetary sanctions. I always think about the case in which they negotiated a settlement for a lifetime prohibition after an individual did not comply. He acquiesced to giving up his firearms and his right to own firearms going forward. And the lawyer in that case in Orange County negotiated with him also to provide some restitution to the victim and to, as part of the restitution, make a donation to Giffords Law Center in recognition of the fact that he had created risk in the state. There are newish order forms that have gone into effect as a result of SB 320. I wanted to highlight some of those. Hopefully you're using the updated forms that are available at courts.ca.gov if you're active in this area. DV 110, DV 130, and DV 820 are some of the items to look at, providing more room to describe the firearm, which is really critical. There's some effort underway to make that even more effective by providing images that victim survivors, when they don't know what kind of gun it is, can say, oh, it looks like this. That's really important in terms of law enforcement being able to remove firearms or seek a search warrant for particular items. The notice forms, DV 830, are out there. Again, focusing on making sure that the right law enforcement agency and the prosecuting agency, these should all be part of protocols that you have in place locally, that they get the information so they can take action as quickly as possible. And there's updates to DV 800, which is the receipt that the prohibited person needs to turn in. If they don't have this form, they can use a receipt from the law enforcement or the FFL, the federal firearms licensee that they're storing it with, or that they sold it to. But there has to be something in the file that shows the compliance. You'll get a copy of this set of slides. This is a checklist that is in the slides, and I can also provide you, or if you want it sooner, feel free to take a picture of this. But these are the key questions that everyone should be asking about protecting folks in your community. Quick mention of ghost guns, unserialized firearms and parts. These are privately manufactured firearms, or PMFs. This matters because without a serial number, not only is the firearm illegal, it can't be registered, which is illegal in California. It also makes it impossible to trace it for criminal investigations. So ghost guns are not just manufactured by 3D printers, that's part of it, but they're also purchased in parts through the internet. We now know that in California, the definition of firearm includes these weapons as well. And that became true as of last year. Another handout you have or will have is a set of key questions to help reduce risk. And this is a really important part of this work, which is how to have conversations about the prevalence of firearm ownership. One of the first questions to ask, depending on your role, is, do you feel comfortable having a conversation with me about whether there are firearms in your life, in your home? If your partner owns firearms, if you need firearms as part of your job or have felt you needed them as part of self-protection, to have those kind of conversations as you would with installing a car seat or access to medications, ensuring that where there's risk, you're engaging in dialogue about how to reduce the risk. You, as a person providing help, can push information out as well. I'm having this conversation with you because the presence of firearms increases risks for people in the home, especially when a family is in crisis or experiencing difficulties related to physical or emotional abuse. And I want to give you some information about that. We don't want unintentional shootings. We want to reduce the risk of teen suicide and adult suicide, of course. You don't want to be involved in a case in which a child gets access to a firearm and does harm in the community. Explaining the significance of firearm risks in these contexts is really important, because the firearm industry is focusing on increasing the number of customers, similar to the cigarette industry years ago, decades ago, where they said smoking cigarettes is good for your health. They are saying that having a firearm is a good way to protect yourself, and that victims of domestic violence should have firearms because it's a good way to provide for self-defense. There is absolutely no evidence of that. The evidence shows that the presence of firearms, even if they're owned by someone who has experienced harm, increases the risk of a lethal outcome for them. And victims of domestic violence have been largely unsuccessful at arguing self-defense or stand your ground laws. Many incarcerated women are there as the result of using firearms in cases of domestic violence to kill or injure their partner. And again, we're not successful in arguing that they were using it self-protectively. So you'll get a handout there. Another resource I want to make sure you have is endinggv.org. It's a new toolkit, primarily for providers in California. It does a great job. I was one of the consultants, and there are other fabulous people on the team. It does an excellent job of walking you through some of the questions that I've posed here. The civil chart is in there, and making a distinction between gun violence restraining orders and domestic violence restraining orders. endinggv.org, brand new toolkit, check it out. Pierce's Pledge, one other resource for you, is an effort by Leslie Hugh, whose son Pierce was murdered by his father. They were involved in a child custody case and wasn't designated as a domestic violence case. And he tragically shot and killed Pierce and then turned the gun on himself and died by suicide. Leslie, Pierce's mom, has launched this pledge effort to have family law attorneys take the pledge to have conversations with their clients about removing firearms while high conflict family law cases are going on, so that people will voluntarily separate themselves and reduce risk in those cases. So I encourage you to check out Pierce's pledge as well. Let me know if you have questions. Current bills in California. We have several that I'm working on with Giffords. SB 599 is designed to address the situation of the tragedy in Sacramento by encouraging judges to consider virtual visitation. Just like I'm interacting with you here, parents can stay in touch with children without setting up unsafe, unsupervised situations like the church. If you don't have a supervised visitation center in your area and you still want parents to maintain contact with their kids, this is a worthwhile consideration. Also gives courts the authorization for them to choose to use their sites as places of exchange or for supervised visits. We're also looking at extending the firearm prohibition and to longer than the restraining order, and ensuring that no matter if someone violates a workplace order or a civil harassment order, that's a basis for a search warrant. Some improvements in the firearms relinquishment in criminal cases is AB 732, and in AB 818, clean up language basically saying that when you serve the orders, law enforcement departments need to serve orders upon request and need to get the firearms at the time that they're serving domestic violence restraining orders. And you've heard a lot from me. You can reach me if you want me to do any consulting, training, presentation, serve as an expert witness. I also do custody coaching for individuals who are going through family court services. You can reach me at that address, and I'm going to stop sharing and open it up for questions. Thank you for listening for so long.
That was great, Julia. A lot of good information. I think I've been through maybe 3 or 4 workshops presented by you, and I actually think that this was the best.
Wow.
And
well,
yes,
thank you.
no, I really appreciate it. I have a few follow-up questions, and I know that I want to give you an opportunity to ask your questions. So Randall, I see your hand. So let's go to you, and I'm going to let you talk, Randall. Oh, you just disappeared. Where are you? I got to find you. Okay. Oh, Randall, there was a mistake. So you, okay, you lowered your hand. Okay. So there is a question in the Q&A. Can you go over firearms storage laws around children?
Yes, sure. First, I'm gonna let me see if I have access to everyone. I'm going to drop this link there because Giffords has the most comprehensive and up-to-date information on this. There are 2 different aspects of what we think of as child access prevention and safe storage laws in California. So those are 2 different things. We're strong in both areas. California makes it a crime, as is pointed out on the website, to negligently store or leave a firearm in the location where you have some control over it. And you know, or you reasonably should know, that a child under 18 is likely to gain access. So child access prevention, or CAP laws, are laws that make people liable after the fact. So they're designed to primarily discourage people from doing the wrong thing, because you know you could be held liable if you don't properly store your firearms. So those are CAP laws. Safe storage laws are a little bit different. You can also be held criminally liable for illegally storing firearms if you can prove a whole bunch of different things. That's a misdemeanor. You are expected to store, as the law requires, a firearm safety device that are listed on the list of approved firearm safety devices that DOJ keeps track of. And so it could be something, it's going to be other than a gun safe, but it's supposed to be able to lock the firearm. It's designed to prevent children and others who aren't supposed to have a firearm from firing. It's not allowed for a dealer to sell one of those devices. It's not on the list. So take a look at that. Federal firearms licensees, firearms dealers have detailed information on that, and you can take a look there.
Thank you. And Julia, can you read the next question, or do you want me to read it in the Q&A?
Oh, let me see. I'll go to the Q&A.
I think I actually know the answer to the question, but Julia, I will let you answer it.
Does SB 320 apply to elder abuse restraining orders? If not, do you have any suggestions for making sure firearm relinquishment orders and elder abuse restraining orders are complied with? So SB 320 does not directly apply. That is, it only under the terms of the statute applies to the requirements. All of the steps only applies to Domestic Violence Prevention Act cases. Now, the prohibition is the same. So you're prohibited from having firearms and ammunition in elder abuse cases involving physical abuse, not in elder abuse cases involving financial abuse, but in physical situations or the kind of abusive situations we're thinking about that are covered under that part of the elder abuse statute. You can, and I would say should, have those same relinquishment procedures in place. That is, the person becomes prohibited. It is required that they turn in their firearms within 24 hours. Within 48 hours, there should be an indication in the file. There is nothing that prevents the court from ensuring that that's happened. And when it hasn't happened, from having processes in place that say, in all of our cases where we've made this prohibition, we as a court are going to look at the file and make sure that this is there, or make it easier for protected parties to go to court and say they still have their firearm. This is a violation. So it may not be required by SB 320, but because that prohibition is the same as the prohibition in the domestic violence case, I would strongly encourage all courts and communities to have protocols to make sure you give some meaning to that prohibition.
Yeah, that was a great question, Emily. Thank you. While you're thinking about some questions, I had a question about the APPS, Armed Prohibited Persons List. So you're saying that there are people who are prohibited by laws to have firearms, but how do you know that they actually are armed? Is it through legal purchases? So then you kind of do the matching of databases?
So in California, here, I'm going to stick this link in the chat as well. This is the legislative report from the DOJ. Every year, they're required to issue the Armed Prohibited Persons legislative report. Mm-hmm. So in California, for you to legally own a firearm, it has to be registered. So when you purchase a firearm or when you obtain a firearm, you need to fill out the right paperwork, register it, similar to how you would a car. And so it's registered. So that goes into the AFS, Automated Firearms System. And that's a California database. And that's a list of all of the people who legally own firearms. And by legally, I mean it's registered. So obviously it's not everyone who has a firearm, because if you have one of those unserialized, unregistered firearms, you're not going to be in AFS. So in AFS, you have the firearms. Then in CLETS, you have the list of people who become prohibited because of any reason, one of those civil orders, one of the convictions. What APPS does that no other state has is it's a database that every day pings both of those systems. So it pings the AFS system and it pings the CLETS database, or within CLETS, I would say CARPOS, right? The protective order registry information, because they're all in CLETS really. And between CARPOS and AFS, it spits out a list of people who are armed, meaning they have a registered firearm, usually more than one, and people who have become prohibited. Now, those people in AFS were completely legal with their firearms until they became prohibited. And now they're no longer allowed. They won't, as soon as they turn in those firearms, they won't be in APPS anymore. They'll still be in CARPOS as prohibited, but because they no longer have the firearm, they won't be in APPS. So they're not armed prohibited, they're just prohibited people.
And who gets the APPS list? your local
That's it.
enforcement?
That's one of the key pieces of information. Every community should know who gets the list. There is at least one law enforcement officer, sometimes the sheriff, generally the sheriff, who gets a printout from DOJ, state DOJ, every month that says, here are the 100, 200, 300 plus people in your county, their name and address, who are listed as having firearms and being prohibited. So every local law enforcement entity should have that somewhere. And that's one of the things I encourage advocates and community leaders to know about. We should all know who gets that. And we can put political pressure on them. We can just have a nice conversation with them and just ask, do you get it? What do you do about it? Because that includes names, addresses, information. And that's what we think of as low-hanging fruit. Let's change that. Let's just get it so that as close to the time of prohibition, people are separated from their firearms.
So what are they doing about it, Julia, in,
Well,
let's say, good places?
yeah, some examples in San Mateo County, they're doing some more coordination so that when someone becomes prohibited, they get good information about how to comply, which reduces the number of people going into the armed prohibited person system. When law enforcement is serving the orders, they are asking for and obtaining the firearms. When people don't turn them in, they then take the next necessary steps, which may be to freeze the scene immediately. It may be to get a search warrant, right? Now you have somebody who, in the gun violence restraining order context, law enforcement has often been quite assertive and appropriately aggressive in saying, we know this person has a firearm or many, and they haven't complied. We're going to take some serious steps about that. That situation in Prince George's County that I talked about, it had been 2 years since this individual was known to continue to have firearms. And then he was eventually able to use it to harm folks. Now, certainly we have this other issue of people getting firearms even when they've become prohibited. I'm not naive about that. And that's why we need to have safer visitation situations. We can't just assume that once you get all the firearms, that's just a moment in time, that they won't get other firearms. So we can't just assume that in-person visits make sense and so forth. But we can do a better job getting those firearms at the time, closer to the time of prohibition. So that's what some folks are doing, is improving, shortening that time, storing them, giving them a chance to sell them, whatever needs to happen. It often turns out that they won't get the guns back because they are firearms that they are illegal or they shouldn't have had for some other prohibition. Sometimes they get them back at the end of the restraining order.
That's great. You mentioned earlier about the $40 million available for implementation of SB 320. Do you have any update on how that money is being spent? What's going on with that process?
Yeah, so there was the first round of funding where money was given out to several different counties who applied through the Judicial Council. All of that money went to the Judicial Council for allocation to law enforcement and courts, and prosecutors to some extent too. So Santa Clara, for example, got some part of the money, and that includes the DA's office, the courts, and law enforcement working on implementation. And I should say it also includes implementation of the gun violence restraining order, trying to produce some consistency across the board. And then there was a second round of funding applicants as well. And I think that was just recently announced too. So you can go to courts.ca.gov and click on the families and children section, and you can see an update on how that money's been allocated. I think it's $4 million of it that's going for evaluation and for administration combination. So the allocation is somewhere under $36 million as well. And I have to say that we had some enthusiastic courts that said, can't wait, communities, and others who said, I don't know how to go about doing this, which to me is a great tragedy, because again, we have to demonstrate that with the right approach, we can make a difference in order to get more permanent funding, not just one-time money. We also have money from the feds under the Bipartisan Safer Communities Act designed to reduce gun violence. we know what needs to happen. We know how to do it. It's really at this point a matter of political will and communities coming together to do what needs to be done.
Yeah, I think that's a really great way to like finish this workshop, but there is one more question we would like to answer.
Okay, let me check it out. Let's see. Are they working on tracking ghost guns? There's a lot of work being done to try and understand who the manufacturers are, how they're being sold, and to try to regulate that. There's some advocacy efforts underway designed to put pressure on credit card companies to not allow credit cards to be used to make it harder to buy and sell them on the internet, for example. Again, one of the challenges is how do you trace an untraceable firearm? And it's very hard to find definitions that work to regulate parts as well. Those who are manufacturing these firearms keep manufacturing pieces of them in ways that make it harder to regulate, because if you're going to buy this piece, it's not really a gun until it's put together with that piece. So we're up against some really significant challenges in terms of being able to trace them. But there's a ton of work being done at the state and federal level to try and get a handle on this. There's a couple of things I hear from law enforcement. They are extremely frustrated and concerned about the trafficking in ghost guns, the harm that's done to communities and to law enforcement officers. So they want to take action about this as well. And I also hear comments like, nobody wants to be the officer who didn't get the firearms that's used to kill another officer or any number of people. That's the kind of decision. While people might be loath to take firearms from someone who's pulled over at a traffic stop, and they may be concerned about their Second Amendment rights, with a brief search, with good information and databases, that might be the perfect opportunity to act to prevent future harm. So I think, most responsible people professionally and personally are very concerned about this issue and are taking steps to do what they can. But it is very difficult to trace them other than to try and figure out. I just went to a conference in Santa Clara. They described a couple of cases that were very concerning, although they were able to take some action around a young person who was young, white, male, who was trafficking in stolen and ghost guns in the Bay Area, driving between various counties, between Contra Costa County and Santa Clara County, selling guns on the internet, driving a Prius, because he said, who's going to think a white guy in a Prius is trafficking in firearms? Was trying to be quite clever and taking advantage of biases around what people assume to be the perpetrators of trafficking in this area, and was, engaging in some very dangerous and serious selling and trading of firearms. So there's teams of people around the Bay Area working together with ATF, with alcohol, tobacco, and firearms agents on this as well. If a victim flees and turns in illegal firearms to prevent abuser from using it against them, will it help with restraining order? If a victim is, let me see if I understand. If a victim flees and turns in illegal firearms to prevent abuser will using against them will help with the restraining order. Maybe that question is being asked, will it help provide further evidence to support the person requesting a restraining order? And in that case, yes, I'd like to believe that that would be useful information to the court. I recognize that sometimes victim survivors may be afraid that they own or have access to illegal unregistered firearms, and that even in the civil context might expose them to some kind of regulation or negative consequences. Again, if they can flee, the first step is develop a safety plan with a domestic violence victim advocate who can help confidentially develop a plan to get those firearms to a law enforcement agency without repercussions for the person turning them in. And there are ways to do that, to call up the agency and say, we have a collection of firearms. I'm going to provide them. I don't know how to make sure they're unloaded. I can lock them in the trunk of my car. We will show up there. Can you come out to the car? And I'll give you the keys. You can open up the car and you can safely remove them from the trunk of the car, right? Because you don't want to walk in with a collection of loaded firearms into a law enforcement agency. And you can thereby sort of create some distance between that person who's fleeing and the return of these firearms to a safer location. And in some instances, that's exactly what they have to do. They have to move to a confidential location because, again, someone who's willing to traffic in firearms may have access to illegally obtained firearms, and we cannot ensure that if they know where the victim is, they won't do harm to that victim. So a restraining order could be helpful. A good judge will take all of that seriously, but remember that information is being provided in a court environment where the other party is then going to know that they turned in the illegal firearms. So that's a strategy that you have to consider carefully. It may be useful and it may be something you don't want to talk about. And I'm not giving legal advice. I'm just saying, have a safety plan.
Yeah, that sounds rather complex, and I would really encourage you to talk to experienced domestic violence advocates in your community and family law domestic violence attorneys in your community, and it'll be really good to brainstorm about what to do about those firearms.
Yeah.
Okay, Julia, I think it's time's up, 11:31. So let me see, there's one more question. Oh, thank you. Well, thank you for the good question. I'm gonna stop recording because I